Labor Committee considered the nomination today. Mr. Scalia is the son of Supreme Court Justice Antonin Scalia. Massachusetts Senator Edward Kennedy chaired the 2-hour and 20-minute hearing.
Very nice to see you. Is this your team? Shove us out of the way.
Good morning, Senator Kennedy.
Good morning. Good morning. The committee will come to order. I thank everyone for joining us as the committee considers the nomination for Eugene Scalia to be the Solicitor of Labor. Mr. Scalia has been praised as a dedicated legal scholar and a lawyer with an extraordinarily good mind. He has had a distinguished legal career at the law firm Gibson, Dunn, Crutcher, as Special Assistant to Attorney General of the United States, William P. Barr, and as an aide to the Secretary of Education, William Bennett. His record makes him extremely qualified for many positions in this administration. However, I've read many of Mr. Scalia's articles, and I have serious concerns about whether his background provides the right fit for the position of Solicitor of Labor, and I plan to explore those concerns today. My colleagues know that this committee has been supportive of President Bush's nominees. In fact, we have already confirmed 12 nominees to the Department of Labor, and we've done so as quickly as possible and are moving quickly on the remaining 3 as well. This committee wants to ensure that the President and the Secretary of Labor have the team they need in place to carry out the important missions of the Department on behalf of millions of working men and women and their families across the country. As the third-ranking official at the Department of Labor, the Solicitor provides advice and guidance on virtually every policy, legislative, regulatory, and enforcement initiative of the Department and its agencies on issues of vital importance to all these working families. In addition, since most labor laws do not include a private right of action, the solicitor serves as the workers' lawyer by using his discretion and judgment to decide whether to enforce workers' rights. As a result, legal decisions and policy decisions at the Department of Labor are so intertwined that they often cannot be separated. When Congress reviews administration nominees, it considers the person's entire background of experience and writings. What a candidate has done prior to his nominations matters to Congress and to the American people. Most of us have serious concerns about Mr. Scalia's nomination to this important position based on our review of his record and his writings, which clearly suggests that his views are outside the mainstream on many issues of vital importance to the nation's workers and their families. Throughout his career, Mr. Scalia has frequently opposed workers' rights. It appears that Mr. Scalia has represented individual workers on only one occasion when particular workers were suing their union after crossing a picket line. He has never filed comments in support of a pro-worker regulation. He has said that employers should not be strictly liable in sexual harassment cases unless they expressly endorse the conduct of the harasser, despite the fact the Supreme Court has held that employers are in fact liable for supervisor harassment in many cases. Mr. Scalia has also encouraged employers to challenge so-called liberal EEOC interpretations of the Americans with Disabilities Act when they are inconsistent with sensible business practice. As solicitor, Mr. Scalia would refer cases to the EEOC and have a role in defining sensible business practice. In addition, Mr. Scalia said that employees should pay for their own safety equipment when the equipment is required by law. Mr. Scalia has also argued that union workplaces should be exempted from certain workplace laws, such as regular OSHA inspections and the overtime requirements of the Fair Labor Standards Act. But if we follow this logic, union workers would not be protected by the same minimum standards of rights provided to non-union workers, thereby undermining the basic function of labor laws, and that's to provide a floor of rights for all workers. In addition, Mr. Scalia has written in very strong opposition to ergonomic protections. For example, he has written, "The science of ergonomics is notoriously doubt-ridden and controversial." He has said that the very existence, not to mention the significance, of repetitive strain injuries is, of course, very much in doubt. He has, in fact, ridiculed the scientific basis for ergonomics. He has written that as a medical science, ergonomics is quackery. Many of us on the committee and in Congress respectfully disagree. The prestigious National Academy of Sciences estimated that 1 million men and women will lose time from work this year because of ergonomic injuries, which will cost the economy $50 billion. There is a wealth of evidence that ergonomic injuries exist, can easily be diagnosed, are caused by workplace practices that are no longer acceptable, and can be readily reduced by simple workplace modifications. In 1997 and 98, both the National Institutes of Occupational Health and Safety and the Academy of Sciences reported similar conclusions. Yet despite study after study documenting the causes and dangers and remedies for ergonomic injuries, Mr. Scalia has consistently argued that ergonomics is quackery based on junk science. I have serious concerns that given this position, Mr. Scalia will be able to provide appropriate advice to OSHA as it continues to work to develop a needed solution to the extremely serious challenge of ergonomic injuries in workplaces across the nation. Mr. Scalia has also been critical of OSHA's record-keeping rule on workplace injuries and illnesses, which is intended to help track occupational injuries and illnesses. As Secretary Chow herself has said, this rule is a big step forward in making workplaces safer for employees. It is written in plain language and simplifies the employer's decision-making process. With upcoming rulemaking on the ergonomic standards, employer payment for safety equipment, and many other major issues, the solicitor will be involved in developing many needed new policies, as well as enforcing the over 180 laws under the jurisdiction of the Department of Labor. The important position of Solicitor of Labor requires a person who has the confidence of Congress and the country in helping to carry out its essential mission of fairly and fully representing the working men and women of America. I look forward to Mr. Scalia's testimony and to explore these cited issues in more detail. Senator Gregg.
Thank you, Mr. Chairman. The Department of Labor is obviously a significant department within our management structure as a federal government, as it administers over 140 labor laws affecting millions of Americans and the American working place. The position of solicitor is equally important, as he serves as the department's chief legal counsel. The solicitor performs an important task not in terms of policy making, but rather in advising the secretary and other division heads about the legality of the actions or policies they wish to undertake. The President's nomination of Eugene Scalia testifies to the importance of this position. I don't think the President could have nominated anyone more uniquely qualified to serve as the Labor Department solicitor than Eugene Scalia. Mr. Scalia has at least 10 years of distinguished experience as a labor and employment lawyer with an unusual broad practice, including collective bargaining, arbitration, Title VII, ADA, OSHA, wage and hour issues. He is a nationally recognized expert in the area of employment law, having written numerous law review articles, including one noted piece on sexual harassment referred to by the United States Supreme Court. Mr. Scalia is a public servant at heart, having served 2 prior cabinet secretaries, and has donated his time as a visiting professor at the University of the District of Columbia Law School. I'm pleased that he's willing to participate in public service and join again in this administration. The chairman has raised a number of issues which he has identified as concerning himself and possibly other members of this panel. I hope that those issues haven't prejudged the decision on this nominee. I believe that this nominee, Mr. Scalia, can answer every one of those issues extraordinarily effectively. And rather than my paraphrasing his answers, I will allow him to do so. But let me simply point out that specifically in the area of ergonomics, this Congress has spoken and said that the proposals of OSHA were not a good idea. that the courts use the term junk science as a legal term, and it is not a pejorative designed by this nominee, but rather a legal term which is used by the courts. And that Mr. Scalia's positions on ergonomics do not differ greatly and are certainly not out of the mainstream than the majority of the United States Congress, which rejected the initial proposals that came forward from OSHA. That in the areas of record keeping, the track record of OSHA on record keeping and the burden which that has put on the small businesses of America could not be worse. And this committee, over the last 4 years, has held numerous hearings where we have pointed out the problems which OSHA has generated as a result of its structure and the manner in which it deals, especially with small employers. I don't know one agency of the federal government, other than immigration, which is unique, that I receive more complaints about in my office from small business than OSHA. And I think raising issues about the manner in which the record keeping is proceeded in OSHA is a legitimate question to be raised, and it is not out of the mainstream. Why isn't it out of mainstream? Because this committee has held hearings on that specific issue innumerable times, as we have tried to make sure that OSHA is more responsive to the needs of the employees in this country. We all recognize that OSHA has come through some tough times. It made some progress under Mr. Deere, and it's unfortunately fallen back recently, but hopefully it'll get its act together. But this nominee's writings in this area, rather than being out of the mainstream, are quite consistent with votes taken by the Congress and hearings held in this committee. So I look forward to hearing from the nominee. I think his extraordinary expertise will contribute greatly to the Department of Labor, and it'll be a pleasure to listen to his input on the issues which were raised by the chairman of the committee. Are we going to have open statements by everybody?
No.
I would ask, Mr. Chairman, since Senator Warner had wanted to be here to introduce the nominee personally, unfortunately, as you know, the Defense Authorization Bill is on the floor, and he's actually been asked to go down to the White House, so he can't be here. So I would ask that Senator Warner's opening statement be made part of the record.
It'll be so included. Mr. Scalia, we'll welcome you if you'd care to introduce the members of your family, or
yes, thank you, Mr.
we'll ask
Chairman.
you to proceed in your own way.
I have some of my family members here today. Beginning immediately behind me to my right is my wife, Patricia, and seated next to her, my son, Jack Christie. She's holding our daughter, Bridget Ann, who's 3 months today. Next to her is Nino, and next to her, our daughter, Megan McCarthy. And next to Megan is Shannon Rice, who's a longtime family friend and babysitter to our children. Also today, seated to my left, Mr. Tom Korologos, who I think is known to many of you and has been helpful to me in preparing for the hearings today. My brother, Paul, otherwise known as Father Paul Scalia, or within the family as Father Brother. My mother, Maureen Scalia, and in the row behind are my sister-in-law, Terry Scalia, my nephew, William, his father, Britt Courtney, my brother-in-law, and son, Timothy. And finally, my brother, John Scalia, seated behind my wife.
Thank you. Thank you very much. We welcome all of them. Thank you. You may proceed in whatever way that you desire.
Thank you, Mr. Chairman, Senator Gregg, and members of the committee. Thank you for holding this hearing today on my nomination to be Solicitor of Labor. It's an honor to appear before this committee. I also would like to express my deep gratitude to the President for nominating me to this position, and my appreciation to the Secretary of Labor, Elaine Chao, for the trust and confidence she has shown in recommending me for the position. The Solicitor of Labor is the principal legal officer of the Department of Labor. The responsibilities of the solicitor are essentially twofold. First, to enforce the nearly 200 laws administered by the department. These include the Fair Labor Standards Act, the Occupational Safety and Health Act, ERISA, and Executive Order 11246. I've spent most of my professional career as a labor and employment lawyer. The laws I've just mentioned and the nearly 200 other laws administered by the department are important laws. They are to be taken seriously. If confirmed, I pledge to enforce them vigorously. I should add that, in addition to the laws I've just mentioned, the effect on American workers and families of the recent events in New York and at the Pentagon have also impressed on me in a way that could not have happened in my law practice. The importance of some other laws administered by the department, namely those having to do with unemployment insurance and providing workers assistance in times of disaster and emergency. The second principal responsibility of the Solicitor of Labor is to provide legal advice to the Secretary and the other principal officers of the department. For instance, the Solicitor's Office reviews draft rules prepared by the agencies in order to identify legal problems and, if problems are found, to help solve them. The Secretary and the client agencies set the policies in these rulemakings. The solicitor's function is to help implement those policies within the bounds of the law. The Solicitor's Office has a distinguished and proud tradition. I appreciate the great responsibility as well as the great honor in being entrusted to carry that tradition forward. I do believe that my experience as a labor and employment attorney has prepared me to faithfully discharge the responsibilities of this office, should I be confirmed. My experience has included litigating under the labor and employment laws, and it also has included providing counsel to clients on the requirements of the laws in order that they can properly comply. I also have taught labor and employment law, and I've written broadly in the area. I'd like to take a moment this morning to address one issue that I have written on and that I know some members of this committee will have questions about, and that is the subject of ergonomics. In my writings, I criticized the ergonomic regulatory proposals of the last administration, and I also criticized the writings by some ergonomists. My pledge to this committee is the following. If confirmed, I will approach the issue of ergonomics as a lawyer for the Department of Labor, and as a lawyer for the United States government. I recognize and understand that I will not be the Department of Labor's scientist, its physician, or its OSHA administrator. I have been nominated to be the department's attorney. To me, the attorney-client relationship is an almost sacred trust. It is a trust where the attorney's obligations are toward others. In this case, toward the Secretary of Labor, toward the OSHA administrator, toward the American people, and toward the rule of law itself. It is crucial to the attorney-client relationship that a lawyer's advice be untainted by any personal preferences the lawyer may have. For a lawyer to shade or slant the legal advice he gives in order to advance a private agenda is among the gravest betrayals of his or her duty as a lawyer. I will be wholly mindful of these things if confirmed as solicitor when addressing ergonomics or any other issue. And I will be mindful of something else as well, that if confirmed, I will have a new position, a new client, and new responsibilities. Necessarily, I will consider all issues from a new perspective. Finally, if the department does issue an ergonomics rule, I will fairly and vigorously enforce it. Any views that I hold on ergonomics pale beside my strong conviction in the rule of law and in the duty all of us have to uphold and obey the law. I've been urged in closing to explain why this nomination is important to me personally. One friend suggested to me that I had the law in my veins. I looked into this, I had a blood test, and I do not have the law in my veins. What I do have is a mother, the Massachusetts-born co-founder of the Young Democrats of Radcliffe, who, when I was 7 or 8 years old, pressed me to read a several hundred-page biography of Samuel Adams. And later, she sat up with me at night to watch a PBS program called The Adams Chronicles. I knew at the time, living as I was in Virginia, that what my mother was doing was somewhat subversive, educating me and John and Samuel Adams rather than Thomas Jefferson, Patrick Henry, and the other Virginians. But in this and other ways, from as early as I can remember, my mother, as well as my father, instilled in me the highest respect for service in the government of the United States and for bringing to that government service the selfless dedication to national ideals that characterized our founding fathers at their best. That, above all, is why I am honored to have been nominated by the President of the United States. It is why I am honored to appear before this committee and all of you today. And it is the spirit with which I would approach the office of Solicitor of Labor, should I be confirmed. Again, thank you for holding this hearing today, and I look forward to answering your questions.
Well, thank you very much, Mr. Scalia. As far as I'm concerned, there's very little doubt about your competency and your basic and fundamental ability. What you're being nominated for now is to be the workers' attorney in the Department of Labor. The Labor Department is one of the few departments that can bring the cases without having clearance by the Justice Department. It has more than 500 attorneys. And there's enormous latitude in terms of discretion about what cases are going to be brought, what regulations are going to be supported, and how kind of protections are going to be out there in terms of in terms of working families. We talked just a minute ago. We'll have 8-minute rounds for the Senator Gregg and myself, and we'll do 6-minute rounds for the others. If that's that okay? It seems to be okay, Judge. I never tried that.
Can we have a vote on? Can we have a vote on that?
We tried. I'm using up my time. So, but I asked that because I make the kind of comment because if you take these decisions, for example, reference was made on OSHA and about the challenges that they had. The interesting fact is that the injury rate in OSHA fell by 26% from 8.6 per 100 workers in 1993 to 6.3 per 100 in 1999, the lowest in OSHA's 30-year history. Real results, lives being saved. Families that wouldn't have had parents do have those parents today. Decisions that are made by the solicitor are life and death decisions. And you or whoever is going to be the Solicitor General is going to be the workers' lawyer. And we've got to look over your record and find out what in that record would give any of us confidence that you have a fundamental core commitment to working families in this country. I find it very difficult to find much there. And I find in many indications ridicule for working families and for unions in your statements and comments. And a disdain for that whole kind of process. Now, maybe I'm wrong about it. That's what this hearing is really about. But it is a very important position, and I know you take your position seriously, and we take ours. These are some of the comments that you've made with regards to ergonomics, with regard to ergonomic. The Home Office's policy, this is in January. Gore unions invite OSHA to your home, Wall Street Journal. home office policy. Most obvious effect will be in conjunction with ergonomics rule OSHA proposed last November. That draft rule itself is a major concession to union leaders who know that ergonomic regulations will force companies to give more rest periods, slow the pace of work, then hire more workers. You can read in that, due paying members, to maintain current levels of production. What's your, do you have a reaction to that kind of reflection of attitude towards workers in the, I'll ask you to make any comment you want to on this issue.
Yes, Senator. I, first of all, have a great deal of respect for labor unions. I believe they do a great deal of good for their members. And I actually, about a year ago, before I had any inkling that I might be nominated for this position, wrote a somewhat lengthy law review article on which I sought to express my respect for labor unions and my appreciation for some of the good things they do. As for that particular comment, what I was attempting to emphasize in that article was the stakes for American businesses of the last administration's proposed ergonomics rule, because I did have concerns with it. And that particular statement was intended to reflect those stakes. I did not mean to suggest that that dues, for example, was all that unions cared about. I do believe that the advocates of ergonomic regulation do so in the belief that will improve safety. And again, in the article I mentioned to you, that was something I sought to emphasize on a more general level, that labor unions do seek safety in a very sincere and effective way.
Well, of course, mostly the support for the rules were made by unions who are already, who already have protections. Listen, here are some quotes, and this is on your ergonomics, OSHA's strange campaign to run American business. Weird science, ergonomist doubtful theories, like a cruise through Disney worlds, Pirates of the Caribbean. To survey ergonomist theories is to glimpse the exotic, absurd, occasionally amusing, and sometimes grisly. Here is in the OSHA strange campaign. There is, however, an alternative conclusion to be drawn from the emergence of psychosocial factors that, as medical science, ergonomics is quackery. These are your statements. Ergonomics, this is in government ergonomic regulation of repetitive strain injury. Ergonomics comprise the most comprehensive agenda for regulating the employment relationship since the enactment of the National Labor Relations Act. If proponents prevail, federal state safety and health agencies would regulate hours worked, rest breaks, staffing, equipment, workplace hierarchy, and opportunities for promotion. Yet the research said to support such regulation is, to a large degree, junk science par excellence. Now, I'll tell you, you can make either comments about any of those.
Yes, I'll refer to two or three and explain them. First, the word quackery. In that part of my article, and it's the same part of the article where some of the other statements that you read came from, Mr. Chairman, I was addressing a particular proposal that had been made by some people on ergonomics, and that's the proposal to regulate what are called psychosocial conditions. Some ergonomists and some fairly well-known organizations had suggested that an ergonomic regulation should, among other things, address the pay and benefits that employees received and opportunities for promotion and other such things. And I disapproved of that idea, as did the Clinton administration ultimately when they excluded that sort of thing from their rule. So, Mr. Chairman, that was what I was referring to, that particular idea. The term junk science, which I have used on occasion, as Senator Gregg noted, what I was doing in that article was looking at decisions by judges, and I was reporting what the judges were saying. The term junk science is shorthand for a Supreme Court test of when scientific evidence is admissible in court. And I looked for cases where ergonomists had been scrutinized under that Supreme Court test. And what I found was that in 11 of 14 cases, their testimony had been excluded in full or in part. That is, the judge concluded that the Supreme Court so-called junk science test wasn't met. And I reported that. But in one of my articles, I took pains to then point out you can't draw firm conclusions from that because, of course, some judges did let the evidence in.
I want to, just in the time that I have left, though, go back to, you had a whole series of articles during all the period, the 90s, 94 on through 2001. Let me just mention very quickly, 1997, we had the NIAR study in July of that. Over 600 studies which were reviewed. NIAR concludes a substantial body of epidemiological research provides strong evidence of association to an MSDs and certain work-related physical factors, and it continues on. That's 1997. And then in October, that's in July, in October, you had this reference in terms of junk science par excellence. No reference to the NIAR study. Then 1998, you have the National Academy of Science did the very extensive kind of a study where they find that scientific evidence shows the workplace ergonomic factors cause musculoskeletal disorders. That's in 1998. And then the Congress appropriates another $890,000. Now in 1999, in March, you have the court's junk science test. No reference to the NIOSH, no reference to the National Academy of Science. And then you have you continued your articles, the rubber manufacturers in July, maintaining your same position. Briefings for the American Trucking, same position. Federalist Society in November. Year 2000 goes on, you continue the writing about the articles. Year 2001, National Academy of Science releases on January 18th its second congressional mandated report in 3 years on the disorders in workplace. In all of your studies, there is absolutely no reference to the National Academy of Sciences or their studies or the NIAR studies. There's no reference or explanation of where they are right or where they are wrong. There's a complete disdain, apparently, for this kind of scientific information in all of your writings. How can we think that you're going to give a fair hearing to workers when we have the most prestigious, distinguished research groups that Congress is constantly, in bipartisan way, asking for their advice, and we have 3 creditable reports, and yet you don't either choose to reference any of them or explain your position against any of them. How you have, I think, just continue to demonstrate a relentless opposition to these kind of protections, and I think some of us need to understand why we should think that you would be in this position any different in terms of the future.
One thing that I did take pains to do in a number of things I wrote was to point out that, for example, musculoskeletal pain, so-called sort of ergonomic pain, is real. It is prevalent. I admonished employers it should be taken seriously. In a couple of the articles that you referred to, Mr. Chairman, I said that many ergonomists are good scientists with valuable suggestions. So I believe that in my writings I did acknowledge that there was much of value there as well. It's true that I did not always cite particular studies on both sides of an issue, and I think probably 2 explanations to your question. One is some of the pieces you mentioned were legal briefs where I was advancing a client's position and where I was aware that the people on the other side of the case were going to be bringing those studies in, and I was trying to draw attention to other studies. And secondly, when I began writing on this issue, I think there was a lot of attention to what was being said, for example, by NIOSH, which you've mentioned, but there, in my judgment, was not much recognition of some of the concerns being expressed by other respectable organizations like the American Society for Surgery of the Hand or the California Orthopedic Association. And I tried to bring those into the discussion as well.
My time is up.
Thank you. I must say I find one of the ironies of the line of questioning that the chairman has pursued is that he is basically saying, as I understand it, not to characterize what he's saying, but the irony is that you're being attacked for attacking a rule which the Congress rejected. On its face, the Congress said this rule wasn't going to work, and yet you're now being attacked for saying, hey, this rule isn't going to work. So there does seem to be an irony there. But let's go over some of the specifics. Congress likes the National Academy of Science, and we listen to it. We like NIOSH. We listen to it. What we didn't like, obviously, was the rule that was proposed by OSHA. So I think you need to separate the National Academy of Science and NIOSH from their findings, which were very legitimate, and then how OSHA took those findings and created a rule out of them, which wasn't consistent with public policy as the Congress decided because it rejected the rule. Is that not correct?
That's absolutely correct, Senator. And I recognize that if I'm confirmed, that I'm going to have an obligation to consider all sides of issues in a way that, as an advocate in private practice, I did not have.
And let's step back. This psychosocial factor, which was being promoted, even OSHA's leadership under the prior administration rejected psychosocial factors, did it not?
That's correct, Senator.
So when you said that that was an application of junk science and a definition defined as quackery, you were making a statement which was essentially consistent with the findings of the OSHA administration under the prior administration, were you not?
That's correct.
The issue of junk science, which is a technical term for, is it the Daubert
That's
test?
correct.
And nobody wanted to give Daubert the credit for it, so they called it junk science. But that was a Supreme Court decision, correct?
Yes.
So you didn't come up with this term?
No, I did not. It's a test that the Supreme Court developed.
And in those cases that OSHA has had that issue raised, is that the right way to phrase it? How many times has OSHA won on those cases?
I looked at two groups of cases, and some of them did not involve OSHA. Most of the reported cases did not involve OSHA, and I don't know the one lost there, though, again, by my count, it was something around 3/4 of the time the ergonomist was not permitted to testify, either in full or in part. OSHA's own cases, to my knowledge, there have been 3 that were litigated to judgment, and I think only one relatively small part of those 3 cases can be called an OSHA victory at this point.
Wasn't that reversed?
Much of one of OSHA's
victories
was, I believe, but in the Pepperidge Farm case, there does remain one small part of that case.
At least in 2, and in the majority of the 3rd case that OSHA has raised, where the issue of junk science has been raised as a legal issue, it has been determined that it was applicable. So it is a term which is applicable and appropriate to certain initiatives which have come out of OSHA. Is that not correct?
I think what I would say is that some of the experts that OSHA has used did not meet the junk science test.
And that's a much better way to phrase it than I did. But essentially, your position is made credible by the fact that courts have supported essentially what you were saying relative to those experts.
That's how I feel about it. I don't believe that the courts were saying that all of ergonomics is junk science.
So you're certainly not out of the mainstream, because the courts found basically what you were arguing. What is your position? It was argued that you've ridiculed, I think was the term, worker families. Have you ever ridiculed worker families?
No, I have not.
And your position on home office policy, what's your position on that?
I thought that the decision announced by OSHA to apply regulations within the home somewhat aggressively was mistaken, and that was the point of my article. And I did, however, in the article note that at the same time, if an employer were sending employees home to do dangerous work, I use the example of mixed chemicals, that was wrong, and that should be stopped by OSHA.
Have you ever opposed any of the hundreds of laws or regulations which would you'd be called on to enforce?
I have not, Senator. I have not opposed any of the OSHA Act or any of those laws or any existing OSHA regulation or any other law or regulation at the department.
Now, you've written extensively on the importance of supporting the civil rights of plaintiffs and unions. Can you go into that a little bit for us?
Yes. I think the two principal articles I would mention are two law review articles I wrote. One I wrote as a member of my law review as a student, and I argued that police who lie at trial and end up leading to a prosecution and possibly conviction of somebody should be subject to suit under the civil rights laws. And in arguing that, I sided with a dissenting opinion that had been written by Justice Thurgood Marshall. I thought he was right in his approach in that area of the law, and there should be liability. A second piece I wrote as a practicing lawyer on sexual harassment, and that piece actually was eventually cited by the Supreme Court in a very important decision on sexual harassment. And the analysis that I set forth there was followed to a degree by the court. I criticized some things that employers were saying about the law in that article.
You also wrote, as you mentioned, an article for the Harvard Law Review, which is a fine university in a great state, with wonderful graduates. And you mentioned you wrote it about a year ago before there was any even inclination that you might be asked to do the solicitor's job. Would you characterize that as a pro-union or an anti-union piece?
I certainly don't view it as anti-union. And I viewed it when I wrote it, and I guess I still view it as pro-union. I spoke at some length about the good things that I had seen unions do for their members, the seriousness with which I believe that they and their lawyers approached safety issues in particular. And I made some suggestions in that article, really suggestions for consideration and discussion, but some suggestions that I thought actually might increase union membership.
Have you ever opposed union organizing drives?
I have never opposed a union organizing drive.
And the article that you wrote was essentially an attempt to say, hey, listen, this is a way maybe it could even be done better.
That's correct, and I intended it in a bipartisan spirit.
Thank you. I see my time is up.
Thank you, Mr. Chairman. I just asked that my opening statement be made a part of the record. Mr. Scalia, again, it's not just the ergonomics rule and whether you've opposed it or not. It's looking back over, it's an attitude. Obviously, the solicitor provides guidance on almost all policy, legislative, regulatory enforcement initiatives of the department. And so you look to past writings and a person's position in the past to try to get some idea of just how vigorously this person would enforce the laws, and not just so much enforce the laws, but in terms of the attitude that will prevail in the solicitor's office over about 500 attorneys. I find also disturbing some of the statements you made. I mean, obviously you appear to be a great advocate for one side of this argument, and that's fine. I mean, I have no problem with the two forces battling it out in court and that kind of thing, and you seem to be a very strong advocate for the business side of the ledger. But somewhere in that past, I'm looking for some little indications that maybe that was your job, but you have some other things that maybe weigh against that. And I'm having a very hard time finding that, especially in the area, one area that I am very concerned about, and that's the Americans with Disabilities Act. We have fought for years to break down some of the misconceptions and to bring people with disabilities into every phase of American life. Not just the workplace, but travel, entertainment, everything. With the passage of the Americans with Disabilities Act in 1990, we made that major step forward of saying this is a civil rights law. ADA is not an employment law, it's a civil rights law, like any other civil rights law.
Yes.
But in that law, we very carefully, over a number of years, working with the business community, I might tell you that the Chamber of Commerce supported the passage of the Americans with Disabilities Act. The only group that didn't was the NFIB, the only business group out there. The U.S. Chamber of Commerce supported the passage of the Americans with Disabilities Act after we'd worked out the language with them. A lot of us here were very much involved in that working that out. But I find your statements regarding ADA to be a little confusing and not in consonance with the law. For example, in an article that you authored here in 1999 in Legal Times, it was a story about the ADA cases, and let me just read what you said in your article. You said the lesson is clear. Just like the prevailing defendants in these cases, employers should not hesitate to challenge agency interpretations of the ADA whenever they appear inconsistent with the law's text, its purpose, or sensible business practices. That's your quote. Well, I'll go on. It says, for its part, the EEOC may be well advised to reconsider its more aggressive litigating positions and interpretations of the Act in order to regain credibility with the courts. I want to ask you, would you agree or would you not agree that, quote, sensible business practice is not the test for determining whether a particular employment practice violates the ADA?
It's not the legal test, Senator. But what I was trying to get across in that article was I was describing a number of Supreme Court decisions that had gone against the...
Two.
I believe there were three, actually.
I think...
Sutton and Murphy and Kirkenberg, I believe.
Oh, yeah, Albert, there were three. You're right, there were three. I thought there were just two. There were three.
And I was attempting to communicate to businesses, which were my clients and my prospective clients, that the Supreme Court had concerns with what the EEOC was saying on the ADA. And therefore, businesses should recognize that they also were within their rights to question certain EEOC interpretations. The sensible business practice line, it's not the legal test. If it were something in the statute and consistent with the policy, it wouldn't matter if there were a business practice that the employer wanted to maintain. However, I do believe that one of the reasons that the ADA was supported by such a broad section, and I share your view that it is an exceptionally important law, but one reason it was supported was that the ADA was written to, for example, require that disabilities be accommodated, but that they be accommodated in a reasonable way. The Act recognizes, I would say, two things. That discriminated against the disabled is not smart business. The disabled offer a great deal to a company. And the Act also, I believe, was written with a sensitivity toward economic concerns, so that, in my view, what the ADA requires is, by and large, something the company would want to be doing anyway.
Now, I personally have a bit of a problem with a couple of the Supreme Court's rulings in that regard, having been through from the start of ADA through the finish of it. Let me just ask you, if you have epilepsy, would you fall under the provisions of the ADA if you have epilepsy? What do you think?
It's hard to answer on any particular medical condition because the Supreme Court and I believe the Congress have made clear that you need to address conditions on a case-by-case basis. But epilepsy would, I think, often be a disability, but perhaps not always.
If you had epilepsy, would you be considered to be disabled?
Well, that's a second way that somebody can get protected under the Americans with Disabilities Act. They may not actually be physically disabled, but if somebody treats them as if they are, they'd have rights. And somebody who's epileptic, even if they didn't meet that test the Supreme Court has insisted on, you're correct, could still be disabled because they were treated that way, and that's not right either.
Would a reasonable person consider that someone who is diagnosed with having epilepsy be considered as disabled? Would a reasonable person?
Well, what the Supreme Court has said, and it was I think a 7-2 decision, is that you have to look at how this condition affects the person on a case-by-case basis once they're medicated. So if the person is completely successfully medicated, it is possible that in that case they might not be disabled. As I say, it's a case-by-case judgment. That person would still have rights, but they might not meet that Supreme Court test.
Well, I want to get, my time's run up, but I'm coming back to that. Thank you.
Senator Enzi.
Thank you, Mr. Chairman. And I particularly want to thank you for scheduling this hearing for today. I think that it's been important that we get the people in place for the administration, and I think that this is a key position for the Department of Labor. And I would hope that we will expedite it after the hearing is over as well. I appreciated your comments that on his character, integrity, and capability in your opening remarks, and those are things that we're supposed to be looking at. I'm pleased to announce my strong support for the appointment. I know that Mr. Scalia possesses outstanding academic as well as professional credentials. Now, one of those the folks in Wyoming will consider to be a little bit liberal, and that's that he was the editor-in-chief of the University of Chicago Law Review. But I'm sure that won't reflect badly anywhere. Our task in conducting this hearing, of course, is to make sure that the presidential nominee, subject to confirmation, is evaluated on qualifications. And I can't envision a better qualified choice for the position of Solicitor of Labor than the person that sits before us today, and the person with whom I had an opportunity to have more extensive discussions on a number of the labor issues that I've been interested in as previously the chairman of Workplace Safety and Training and now the ranking member of Workplace Safety and Training. And I think that he has a great depth of understanding in those areas, and in line with the questions that have been done today, though, I think it's important for us to note what the role of Solicitor of Labor is and is not. The Solicitor is the chief legal officer of the Department of Labor. The responsibility is to enforce the laws under the Department's jurisdiction. The Solicitor is charged with advising the Department about the legality of the actions the Secretary and other individuals at the Department wish to pursue. And the Solicitor's position is not an ideological one, nor is it a policy position. The Solicitor opines on the legality, not the policy of proposed actions by the Department. And I would ask that a considerably longer statement that I have prepared become a part of the record.
It'll be so included.
Thank you. I do appreciate the statistics that the chairman pointed out at the beginning of his remarks on the way that OSHA has improved, and I'd like to think that part of that improvement in the statistics on the safety of workers has come from the collaborative efforts of particularly the senator from Massachusetts and the senator from Minnesota and myself in working to make sure that we had a consultation part to any of the work that was done. There are a number of things that can be involved in improving worker safety. Even a hearing such as today's will improve worker safety. It will show a concern across the country that we have for safety. And I hope that we can bring out during the course of this some of the things that can improve safety. Ergonomics is one of the things that you've been questioned on here today. During the debate that led to both the Senate and the House repealing the ergonomics rule, California was used as an example, and they were shown to have a more consultative approach. Perhaps because of the debate and the mention of California, they thought that it was important to bring up before their legislature the ergonomics rule that we had. And it's interesting to note that California evidently agreed with some of your writings and saw that it was not the right piece of legislation for the state of California as well, and they're usually considered leaders in safety. I also appreciate the comments that you've made about OSHA in the home, and have to mention that I think that was kind of a unanimous decision, not only by OSHA, but unanimously approved by the members of this committee. That would be overreaching the boundaries and putting into place some enforcement that would not be possible. There have been some varying numbers on the number of statutes that you'll have to enforce. I think they're about, but the numbers that are varying depend on whether we include executive orders and rules as well as federal statutes. But regardless of whether they are federal statutes or rules or executive orders, you've been practicing labor law and employment, been an employment lawyer for over 8 years. During that time, have you ever opposed any of the more than 180 laws that the department is responsible for enforcing?
No, I have not, Senator Enzi.
In the wake of the congressional nullification of OSHA's ergonomics rule last March, the Department of Labor is formulating a comprehensive approach to addressing ergonomics in the workplace. I recognize that you have expressed criticism of the nullified ergonomic standards. I want to note that this criticism was shared by many other lawyers practicing in the field. In fact, this opposition was shared by, of course, as we've mentioned, to both the majority of the House and the Senate. If you are confirmed, are you, in your capacity as solicitor, committed to administering or enforcing whatever approach the department determines is the best way to deal with ergonomics hazards in the workplace?
Very, very much so, Senator. It would be my obligation as a lawyer and as a subordinate and public servant to the Secretary of Labor.
Thank you. I see that my time has expired.
Senator Wellstone.
Chairman, are we going to have a second round for questioning? Can I ask you? I'm going to take the first part for a statement and then hopefully get into some questions. Mr. Chairman, as I see it, the Solicitor of Labor is not just the Department of Labor's lawyer, but really the workers' lawyer for the whole country. He or she is responsible for enforcing the most fundamental worker protection measures on the books, which have been won through decades of struggle and sometimes even with blood. The minimum wage, the 40-hour week, occupational health and safety, mine safety and health, workers' comp, family and medical leave. The solicitor, Office of Solicitor, is responsible for more than 180 federal laws that cover roughly 10 million employers and 125 million workers. Before I get to some questions, which I think are important to have on the record, let me just say that I met with the nominee in my office some weeks ago, and I really enjoyed the meeting, and I have a great deal of respect. I want to say this on the record before I say one other thing. I have a great deal of respect for Mr. Scalia's intelligence and his capabilities as a lawyer. And whatever happens, I wish him well. And if he is the solicitor, I wish him well, and we will work together. But I cannot support his nomination to this position because I believe after reviewing his record and a number of his writings, I don't believe he's the right person for this job. His professional record of apparent antipathy toward the very laws and principles that would be his job to carry out make, I think, this a mismatch, at least in my view. Mr. Scalia seems to have been opposed throughout his career to what I see is the very mission of the Solicitor of Labor. That's why I can't support this nominee. Now, the President is entitled to nominate people that he thinks are right for his administration, and I'm supporting the vast majority of his selections. But as chair of the subcommittee with jurisdiction over OSHA and the Fair Labor Standards, the National Labor Relations Act, which is separate, Mine Safety and Health, and others, I see this nominee in a different light. At a time when many working families face a tremendous amount of economic security, I think it's really important that we need someone who would instill much more confidence that the Department of Labor is going to be on working families' side. And I do not believe that Mr. Scalia can instill that confidence. I wanted to say that because we couldn't all make statements at the beginning, Mr. Chairman. Let me make a transition to some of the questions which have led me to this conclusion. I'll go back through a little bit of what was said earlier, but I'll go in a different direction. Mr. Scalia, you've written that you thought that workers liked repetitive stress injury regulation because it reduces the pace of work. That's quote, it reduces the pace of work. And you said that unions like such regulations because, quote, with the pace of work reduced, more workers would be needed to maintain the level of production. Consequently, union membership and dues would increase. That's all in quotes. October 1977, Government Ergonomic Regulation of Repetitive Stress Injuries. Now, during OSHA's March 20th repetitive stress injury hearings last year, there was a testimony from Mr. Walter Frazier. It was riveting. He was a poultry processing worker employed at the Allen Family Foods on the Eastern Shore for 9 years. Mr. Frazier told of hanging live birds above his head at 26 birds a minute and rehanging birds that had been scalded at 70 birds a minute for 8 to 10 hours a day. He described numerous repetitive stress disorders, some requiring surgery. He then described how his injuries affected his life. He told of always being in pain, of the difficulty of lifting his granddaughter, the pain in mowing the lawn, and doing all the normal things of life. This is the basis of my opposition. Mr. Scalia, I mean, as I try to juxtapose some of what you've said and Mr. Frazier's life, do you think Mr. Frazier's account was a ploy to get more break time? Do you think that the pain that Mr. Frazier was experiencing was all in his head? Do you think the work that he did might have caused the problems he describes? And is it truly your position that the union that was supporting Mr. Frazier was supporting Mr. Frazier because they were hoping that by slowing down the line, they would hire new members? And finally, does Mr. Frazier deserve to be protected from sustaining this kind of injury?
There are a lot of parts to that question.
I know.
I'll try to keep them all in
and
mind.
take whatever you're most comfortable with. And
First of all, I very much enjoyed meeting you several months ago, and I appreciate your taking the time to do it, and I hope I get the chance to work with you.
I appreciate that.
The job you describe is one that has been identified as causing ergonomic difficulties. And I have written that those kinds of jobs may well cause injury. And I've urged employers to address complaints of pain. I actually have quoted a physician to the effect that patients don't lie, that they are feeling the pain. It can be difficult sometimes to determine the exact cause. But in that case, it may well be that Mr. Frazier's job caused his problem, aggravated a problem, or otherwise contributed to the problem. An employer with employees experiencing those kinds of conditions ought to do something, and I've written that. And certainly, Mr. Frazier's safety and health ought to be protected. Again, it's hard to know all the facts here, and hard to know whether in that particular case there was an OSHA violation or would be under an ergonomics rule. But it's certainly something that ought to be of concern to OSHA as well as to Mr. Frazier's employer.
My time's up. I'll come back to it. Thank you, Mr. Brown.
Senator Collins.
Thank you, Mr. Chairman. Welcome, Mr. Scalia.
Thank you.
You've been nominated for a very important position, and I think the number of members at this committee hearing this morning shows that we consider it to be a significant role. So in preparation for this hearing, I've spent considerable time not only talking with you, but also reviewing your readings, looking at the letters both for and against your nomination. And I must say that I was impressed with the many people representing a wide range of ideologies who have written in support of your nomination. I don't think that would occur if you were, as some have portrayed you, as against working families or anti-union or a right-wing ideologue. I don't think any of those are true based on my complete review of your writings. And I think it's important that we get some of those letters entered into the record. For example, we discussed some writings that you'd written on sexual harassment. And one of the article that I read was a pretty provocative article. You explained to me your views on that. I'm completely satisfied. But I think as more evidence of the esteem with which you are held is a letter from Justice Ruth Bader Ginsburg, which she has given permission to be included in this hearing record. And I would like to just briefly read it since it is a short letter. And it is with regard to a sexual harassment case that was before the Supreme Court. And Justice Ginsburg writes, "Dear Gene, looking out to the courtroom audience this morning, I wish we could have invited you to present argument. All would agree, I think, that whatever we do in these cases, we should leave the force less dense. Your article is written with refreshing clarity and style. It is informative, thought-provoking, altogether a treat to read." And Mr. Chairman, I would ask that the letter from Justice Ginsburg be entered into the record. Similarly, we have letters from legal scholars, from a legal scholar who is a former AFL-CIO lawyer, all pointing out how extremely well qualified you are for this post and that they believe you will serve very well. I think it's important, in view of the questions that have been raised about your position on ergonomics, to talk about some of your other writings. For example, you wrote, and you referred to this in response to Senator Wellstone, that patients do not lie about musculoskeletal pain and discomfort. Indeed, such pain is prevalent. Employers should consider a global medical protocol aimed at ensuring that such discomfort is treated but not improperly diagnosed. Again, a company should not ignore legitimate complaints of pain and discomfort. Industry should continue to examine the relationship between repetitive work and injury, just as it should continue to take into account human factors in engineering. So my question for you is really straightforward. Do you believe that there are cases in which the work environment produces a repetitive stress syndrome such as carpal tunnel?
Yes, I do.
So you're not saying that there should be no regulation in the area of ergonomic. Is what you are arguing for is a science-based, carefully drawn regulation?
I believe that the science requires very careful attention. And if there is to be a regulation, yes, that it must be carefully based in the science. As to whether there's to be a regulation, that's a decision that the Secretary and the OSHA administrator would make, and that the solicitor would not be involved on a policy basis in making.
Which brings me to my second point, and that is what your role would be at the department. It is not your call whether there's going to be an ergonomics regulation. Is that not correct?
That's correct, Senator.
And indeed, Secretary Chow has indicated that she is now marshaling the information and attempting to come up with an approach to ergonomics that wouldn't involve the 608 pages of regulations that Congress decided did not address the problem properly and thus were repealed. But your role is to provide legal advice, a legal roadmap, if you will, and not policy advice on what the context or contents of these regulations should be. Is that accurate?
That's absolutely correct. And in fact, the Secretary and her team are already fairly far down the road toward deciding precisely what course they will take on the issue of ergonomics. And those are discussions that I have not had any involvement in at all or really much knowledge about.
Mr. Chairman, I think it would be unprecedented for us to oppose a nominee who is eminently qualified for this post simply because he opposed a 608-page regulation that does not exist because it was repealed by a bipartisan majority in both the House and the Senate. I hope we will not go down that road. I think it would be unfair and would deprive us of the services of an individual who is eminently qualified for this post and whom a wide range of objective observers on both representing all sorts of ideologies have spoken so highly of. Thank you, Mr. Chairman.
Thank you very much. Senator Murray, or I understand Senator Edwards has to leave just before 12 to preside. Is that correct?
Mr. Chairman, I just have a couple minutes if I could just quickly ask my question, and I'd be happy to yield my remaining time to Senator Edwards.
Fine.
If I could. Let me just thank the chairman and welcome Mr. Scalia here, and let me just focus on one area, and that's the area of sexual harassment laws. And I was looking at a Harvard Journal of Law and Public Policy article that you wrote in 1998 that basically you reject the notion of quid pro quo sexual harassment lawsuits against employers and argued that the employer should not be liable for the harasser's conduct unless the employer endorsed it. And I wanted you to explain to us what you meant. Do you mean that the employer should not be liable for quid pro quo sexual harassment that's perpetrated by supervisors or even executives of the company while on company time?
In that article, I actually very strongly condemned quid pro quo sexual harassment. Can't remember the exact terms I used. I think I described it as extraordinarily offensive. I think I called it perhaps the most offensive form of sexual harassment. I was making the point that a legal test some courts were using was confusing, and in fact it was unfair to plaintiffs. And that was the main point of my article. I did talk briefly about the strict liability issue. I just commented in passing that I would tend to think that you would look for some evidence that managers knew about the harassment.
Well, I think what you said is that they should be only liable when they endorse such improper conduct. And does that mean that they have to affirmatively endorse it and say that we allow this? Or do you believe that they should be liable even if they only knew about it or turned a blind eye to it? How does someone endorse it?
I believe the answer is that under the law, the employer could be liable in both circumstances, and I think that's the right answer.
Whether they endorse it or not?
That's right. If they affirmatively say that's okay, or if they know and do nothing, I believe that under the law they can be liable, and I think they should be.
Okay. Thank you, Mr. Chairman.
Senator Edwards, did you want to?
Thank you very much, Mr. Chairman. I thank my colleagues. Good morning, Mr. Scalia. Mr. Scalia, it's clear to me from having reviewed all these materials about your background, and I don't think you and I have met before, if I'm not mistaken, that you have a great deal of skill, training, legal acumen, and you've been a very good lawyer for employers. My concern is, I think in this position that you've been nominated for, you will have the responsibility of being a lawyer for the nation's employees, and among other things. And I'm concerned, based on all the things I've read, I think there are legitimate arguments about a number of these issues that you've been asked about this morning on both sides. But my concern is is finding in your record, as I've looked at it, what I think is a necessary empathy for workers in order to adequately and properly represent them. As I'm sure you know, the OSHA statute, among others, which you would be responsible for helping enforce, there is no private cause of action. So the solicitor is the person responsible for determining whether there's going to be a case brought on behalf of employees against whoever's involved. Let me just ask you a couple of factual questions. Can you tell me how many times over the years, approximately, you have represented corporations and employers in disputes with either government agencies, unions, or employees?
I don't have a number.
Can you give me some idea of how many times, approximately?
I'm sorry, Senator, I would be guessing. But what I would emphasize is that though I handled a number of cases for employers, a large part of my practice also was to counsel employers. And in that capacity, I felt that I had a great obligation both to the law, to make sure these people knew what the law was, and also to the employees. I think it's not often appreciated that a lawyer who represents a company in labor management type issues often gets in a bit of an argument with maybe a manager and says, you can't do that. And I filled that role a lot, Senator. I spent a lot of time on the phone saying, I'm sorry, you just can't let that person go.
Can you tell me what percentage of the time that you spent in the practice of law was devoted to representing and counseling employers as opposed to employees?
I represented employees very seldom. That was not regularly part of my practice.
How many times did you actually represent employees in disputes against employers or corporations or corporate associations?
There are two matters that I can recall that didn't go to litigation, but they were counseling matters where I helped people. In one instance, a pro bono basis for a woman with a hearing difficulty. But in litigation, I don't believe I had cases.
Okay. So on two different occasions over how many years have you practiced law now?
I was in private practice, I believe, for 10 years.
10 years. So over that 10 years, you had two cases where you represented employees in some capacity, and the remainder of the time you were representing employers, corporations, et cetera. Is that correct?
I was representing those employers or entities in one capacity or another. As I say, it might have been to counsel them on their obligations. It might have been in a non-employment matter in some circumstances.
Would you agree that one of your responsibilities for this position that you've been nominated for would be to represent the laborers, the working people around America?
My responsibility would be to represent the government of the United States and enforce the laws, which I would do vigorously. In that capacity, I would be acting to vindicate the rights of working people in many kinds of cases. They wouldn't technically be my clients, so I wouldn't technically represent them, but I would enforce those laws vigorously to their benefit.
Okay. And you were asked by Senator Wellstone about a particular employee who testified about hanging chickens and working in a poultry plant. And down from the part of the country where I'm from, my father worked in a cotton mill most of his life, and my mother worked in a cotton mill some part of her life. Just out of curiosity, have you yourself ever had any personal experience working in a manufacturing plant or the kind of poultry facility that Senator Wellstone was asking about?
No, I have not worked in a facility like that.
Thank you, Mr. Chairman.
Senator Sessions.
Thank you, Mr. Chairman. And I want to thank you. And I know Senator Edwards and Senator Wellstone were asking about who you represent, but as a former United States attorney, you do represent the government and the laws that the Congress passed, and your responsibility is to enforce them equally and properly and fairly, and you well stated that, and I think that's important for us to remember. We want an objective counsel as a counsel to the Secretary of Labor. Your background is just marvelous, Mr. Scalia. University of Virginia with your bachelor's degree there, one of the great universities in the world. Your law degree from the University of Chicago, one of the great law schools in all the world. You are editor-in-chief of the Law Review at the University of Chicago, which, for those who don't know, that is the most prestigious position of any graduating senior. And to do that at a great law school like Chicago is an extraordinary achievement, and one I think you can take great pride. And you've also spent your career with Gibson, Dunn and Crutcher, one of the great law firms in America. So I just want to say that in this regard, and you spent most of your career doing labor work, representing the clients of Gibson, Dunn and Crutcher with fidelity, with objectiveness and fairness, and I haven't heard anyone that's litigated against you come forward and say you're dishonest, unfair, unobjective. And I think you've got an extraordinary background. And for the Secretary of Labor to reach out for someone of your quality speaks well for her. So I think she's entitled to one of the best lawyers in the world to represent her. I think you're one of those. And I suppose you will give your level best to advise her according to the law as your best judgment helps you find it. Is that correct?
I would. That would be my obligation.
And with regard to the regulations that are in force in law and that may become law in the future, will you give her your best advice on how to fairly and objectively enforce those laws?
Yes, I would.
And if the Supreme Court rules that in a certain way, whether you agree with it or whether you don't agree with it, will you advise her on how to enforce the rulings of the Supreme Court and other courts as appropriate?
Yes, I would, Senator.
Well, I think that's important. And you know, this article you were asked about in the Wall Street Journal, it was a reaction to this OSHA advisory to go far beyond anything we've seen before to regulate homes, to have OSHA inspectors apparently go into homes. It resulted in a real reaction across the board, as I recall it. And your article was written as part of that reaction to that proposed advisory, or that advisory. Is that correct?
That's right.
And that advisory was withdrawn by OSHA itself, was it not?
That's correct.
And this committee, to my knowledge, not a single one on this committee, not a single person in the United States Senate, to my knowledge, has ever objected to the withdrawal of that advisory, which went far beyond, in my view, a legitimate action of OSHA. So I don't think your article that was aggressive and to the point was extreme. It reflected the considered opinion of the Senate and even the OSHA leadership when the issue was raised to them. Mr. Scalia, you've written about some of these regulations, and as a former federal prosecutor, I've had to enforce laws and regulations myself. Your concern, let me ask you this, is your concern out of the fact that you know they will be enforced, you've seen how rules and regulations are enforced in the legal world, and that they need to be good regulations, and if they're not, bad things happen?
I have a great deal of respect in the law, in the rule of law, and employers complying with the laws in the books. And for that reason, I think it is important that we take great care in the laws we formulate.
And you've had to advise clients to enforce laws, I'm sure, on occasion that didn't make much good sense to them. Is that right?
There certainly were times where clients didn't quite get why they needed to do the kinds of things that I advised them legally they had to do, but I told them it was the law. I think you're going to find in Secretary Chow that you have a tremendous leader. Just this past week, I traveled with her to Brookwood, Alabama, where we had 13 coal miners killed in a mining accident, the worst since 1984. And 10 of those died responding to help 3 others, gave their lives for their fellow brother miners. And we had a marvelous memorial service that finished around 8:30. Secretary Chow had a plane out of Birmingham at 6 a.m. the next morning. Despite that, she went to the Union Hall and spent 2 hours visiting with everyone there, not leaving till after 10 o'clock. I think she is going to provide great leadership and concern for the working men and women of America, and I think it's going to be wonderful to have someone of your caliber help her enforce the laws effectively. And Mr. Chairman, I would just note a couple of things. Cass Sunstein, one of the more notable liberal professors in America and at the University of Chicago Law School, wrote recently, "I know Gene well. I think he's an excellent choice, first rate, not at all an ideologue. Gene was a sensational student at the University at Chicago, one of our very best. He was elected editor-in-chief of the Law Review, not only because he's so smart, but also, and maybe even more so, because he's a wonderful human being." You volunteered as an unpaid professor to help the D.C. Law School here when they were having financial troubles, and Dean Robinson wrote, "I found Gene Scalia to be a dedicated legal scholar who looked past labels to make a more thoughtful judgment, took a balanced, non-ideological approach to his teaching, and was respectful to his students." William Coleman, former president of the NAACP Legal Defense and Education Fund, wrote to this committee saying, "I have every reason to believe that his performance at the end will place him among the best lawyers who have ever held that important position." And I would agree. I think this nominee is extraordinarily qualified. He has a history of balance and commitment to law and will be a great asset to the Secretary of Labor. And it's important that we move forward with it. And I thank the chairman for allowing us to have this hearing today.
Thank you very much. Senator Reid.
Thank you very much, Mr. Chairman. Thank you, Mr. Scalia, for joining us today. It seems from reviewing your writings and also listening to your responses today that you do recognize there are many wrongs in the workplace, but you don't seem to see there are many regulatory responses that the government can take effectively to correct those wrongs. And that's a disturbing point for someone who is going to be proposed as the Solicitor General for the Department of Labor. In response to your questions to Senator Collins about the proposed ergonomics rule, you left the impression, I believe, that you would have a very limited role in that. Is that the correct impression that you'd like to leave with the committee as the Solicitor General?
The solicitor has a defined role. It's an important role, but it's a role dedicated toward providing legal advice. So, for example, in a rulemaking, the solicitor would say there's a range of legal options before the secretary, before OSHA, and here is the sustainability in court of the different courses of action you might take. It is not the solicitor's job, however, to opine on medical issues, scientific issues. That expertise lies elsewhere in the department. So, yes, the role would be limited in that respect. Secondly, I believe I mentioned earlier in the response you were referring to that the Secretary's decision on ergonomics particularly was already one that was in the latter stages, close toward a decision, and that I hadn't been involved in that actually at all.
So as a solicitor, would you accept the premise that the science was junk science, or would you see the science as very valid, pointing to the need for regulation?
I have never said that all the ergonomic science is junk science, and I don't think it is. Whether it supports a regulation, again, the evaluation of that scientific evidence is something that falls principally with the experts within OSHA.
Well, so you could conceivably recommend to the Secretary that no regulation is required as a lawyer because the scientific evidence has not been conclusive to you, even though you don't present the scientific evidence.
As I understand the working of the department, it's OSHA and personnel within OSHA that take the lead in assessing the scientific and medical evidence. I can't imagine myself, if I were confirmed as solicitor, reading individual studies and calling up the OSHA administrator and saying, here's what the science says. At some point, a legal judgment is necessary based on recommendations reached by OSHA on whether that rule is sustainable. And as I say, I don't see the solicitor's office as being an on-off switch, but rather as presenting the range of legal options and the sustainability of them.
I think you have a very circumscribed view of what the solicitor does as the key advisor to the Secretary of Labor, not just on this issue of ergonomics, but on a range of issues, making judgments about not just the sustainability in court, but whether or not this is an appropriate response of the government to a real problem. And if you're going into this office with that kind of circumscribed view, first I think it's rather artificial. And it comes to the whole essence, which is one of the difficult issues of public policy. Where does policy end and the law begin? I suspect it's almost impossible to find out in most cases. And so in your role, you're going to make key judgments about value judgments, about what's important, not just procedural about where do we file this case and what would happen if someone sued us, what court we'd be in. And if you don't appreciate that and evidence that in your remarks today, then I just think you're missing a major point of what you're going to be doing. And it gets back also, I think, to not just to the skills you bring to the job, but the spirit you bring to the job. Whether you are going to be the lawyer for people who work every day, need someone to look out for them, or whether you're going to be the lawyer for the government or those special interests which influence the government. Many times they're not the working people that need the help of the Department of Labor. Let me turn to another point. With respect to your writing in the strange career of quid pro quo sexual harassment, you seem to say that unless an employer is should only be directly liable if they endorse or ratify the act in question. That is a fair statement of your view?
I don't recall exactly what I wrote on that. I believe that what you're referring to, Senator, is maybe a sentence or two at the very end of the article where I think I said, some see it this way, some see it that way. I probably see it this way, but that's not important to my article. And I believe that's, in short, how I dealt with it.
I'm sorry. Excuse me, go ahead, please.
This area of the law is a little bit difficult right now in light of the Supreme Court decisions, I believe, from 1998. The law is a little bit unclear. So it's hard for me to say this is the legal answer right now. But
why don't you give me your answer?
As a policy matter?
as a legal matter, as a policy matter, as a matter of what the law should be, any way you want to describe it, should an employer be liable only if that employer endorses or ratifies the act in question?
In this article, I wrote very strongly against sexual harassment, and that was the message I was communicating. As to employer liability, I would not limit it to cases where there's been endorsement or ratification. If there's knowledge and it's not fixed, that's a basis for liability, I believe, under the law, and I think that's how it should be. It ought to be stopped.
Does that represent a change from the view you took even peripherally in this article of 1998, just about 3 years ago?
I'm sorry I can't answer that, Senator, because my article wasn't about that issue. I may have made an observation in passing, but I just did not have firm thoughts on that point.
Again, it seems to me that someone who is crafting an article for a law review through the various editorial processes, and you were the editor at the prestigious law journal, as Senator Sessions pointed out, that there's not a lot of throwaway language in those articles. There's not a lot of sort of, let me just say off the cuff. And it's, in preparation of this hearing, I would assume that you would at least have a grasp upon every point of the article, but apparently you don't.
Well, I try to write carefully, but again, this was not a point that was the subject of my article, and I do think, again, if an employer has knowledge of sexual harassment, it ought to be stopped because that's the right thing to do, and because, as I understand it, that's the law. What I said on this at the time, I'm afraid I don't recall.
Thank you very much, Mr. Scalia. Thank you, Mr.
Thank you very much. We'll begin a second round, if we could. On the, as you have obviously concluded, the principal kind of questions that people have in mind, at least in one important area, is whether in the areas of ergonomics and that whole history of this, that you have been able to not only represent your clients, but also in your writings have been sufficiently understanding of what the interests of workers and their health needs are in the light of very substantial, I think overwhelming, medical science in the NIOSH and the Academy of Sciences. I find myself that you come up short. The reference was made earlier about the junk science, and reference was made as a Supreme Court use of those terms, but that, as I understand, dealt not with issues of health related, but with product liability. These are the other words you use, and this is in the year 2000, but the science of ergonomics is notoriously doubt-ridden and controversial. That's in the policy analysis at the Cato Institute, May 2000. This is another in the San Francisco Daily Journal, writes an article. This isn't representing a client. But no agency should be permitted to impose on the entire American economy a costly rule premised on a science so mysterious that the agency itself cannot fathom it. Here is in the San Francisco Daily Journal in July of that year. This vague and subjective rule would afford little benefit to workers because it's based on thoroughly unreliable science. Those statements and comments are all made after these publications of the Academy of Science and NIOSH, and they are enormously troublesome in the sense of whether you can really separate your own views, because the articles that I referred to are not representing a client. They are your own conclusions. Now, let me ask the question. If you were, you've said in your written statement that as Solicitor General, you'd only be able to providing legal advice to the Secretary on ergonomics, not policy advice or scientific advice. I find it difficult to believe that legal advice can be easily disentangled from policy and science. For example, the Secretary has said that she's developing a comprehensive approach to ergonomics that may include a new regulation. Before it can issue a regulation, OSHA must demonstrate the hazard in question poses a significant risk of harm, and the standard will reduce that risk. Now, you're intimately familiar with the record of evidence on ergonomics, including the scientific evidence. So, and I want to know that as the Department of Labor's chief lawyer, what would be your legal advice to Secretary Chow on whether there's a legal basis to support an economics regulation?
Mr. Chairman, unfortunately, I am not particularly familiar with the record evidence that was put in the last rulemaking. It was so vast that I have not reviewed it to any sufficient degree to state whether a rule is supported. One thing I will say is that in litigation that I was involved in California over the California ergonomics litigation, or California ergonomics rule, in that litigation I did not raise a significant risk challenge to the California rule. So at least in that one circumstance, and in view of the circumstances in that one regulation, I was not involved in arguing that significant risk hadn't been shown.
Well, this is, I'm really more surprised at this answer than anyone you've given earlier, quite frankly. You've been writing about this now for over 6 or 7 years. You've been one of the most prolific writers on this, on this whole issue. And given the fact that you've written about this, represented different clients, you must have, in your representation of different clients, understood obviously what the other side's going to say. You must have looked at the other opposition, people that are taking a different position. And this is a very, very simple question. This is a very, very simple question. And if you can't answer that question, based upon it, you've lost me. Absolutely lost me. That might not be important, but that is beyond belief in terms of the fact that you've been writing about this for 6 or 7 years, been one of the most prolific writers. You write about it in great detail and represent it, and all the question is, given all the evidence to meet these particular requirements, the issue is, does it propose a significant risk of harm, and that the standard will reduce the risk? And you say you can't give us an answer on that because you're not familiar with the evidence out there. Now that's, let me go on to another issue.
If I could answer that briefly, Mr. Chairman. Certainly what you think is important. And what I meant was that the record, the evidence that was assembled before OSHA, I don't know what that record evidence is. As to what's out there in the larger scientific community, I don't know the scientific answers, and I've never said that I do because there is so much uncertainty among the leading experts, and I think there has been an effort, I think the recent NAS report reflects it, to come to consensus and agreement, and I think perhaps there's been progress, but I have found it, I have never tried to say this is the answer or that is the answer. I have instead pointed to what scientists themselves are saying about how things can be difficult in this area.
Well, let me go to another area. In 1999, the OSHA proposed a regulation to make clear that employers' legal duty to provide a safe workplace under Occupational Safety and Health Act includes a duty to pay for safety equipment, such as gloves and goggles and other personal safeguards, when safety equipment is required by an OSHA standard. The rulemaking was needed because of decision by the Occupational Safety Health Review Commission, which said that the standard requiring employers to provide safety equipment didn't necessarily mean the employer had to pay for the equipment. OSHA's proposed rule is still pending now in OSHA. Because of the Review Commission's decision, we currently have a situation where employers are not required to pay for many of the basic kinds of safety equipment, even though the equipment is required by OSHA standards. Many employers do in fact pay for safety equipment, but some refuse to pay, instead make the workers pay. This is particularly true in low-wage industries where workers are unorganized. For example, in the poultry industry, some employers require workers to pay for mesh gloves and what they call armed guards needed to protect against cuts from sharp knives. These workers make $7 an hour. The cost of one mesh glove is $65 an hour, and the employers deduct the cost of the equipment from the workers' paychecks. You co-authored comments on OSHA's proposed rule on behalf of your client, UPS, and those comments oppose the rule and urge OSHA to withdraw the rule in its entirety. The comment argued that the rule was a naked allocation of economic benefits and is not a health or safety standard, and consequently was beyond OSHA's mandate. The comments actually said the rule could be harmful to worker protections. Now, I recognize you wrote those comments for a client. I'd like to know what extent those comments reflect your personal views.
It was written for a client, Senator, and in fact, I noticed that I was one of 5 lawyers who worked on that document. I did not have particularly great involvement in it. I can't say that when I wrote the parts of those comments that I worked on that I was advancing personal views. I don't know the law in that area particularly well, and didn't have any of my own personal feelings about that issue.
So do you believe that OSHA has the authority to issue the standards that require the use of safety equipment like respirators, mesh gloves, goggles, protect the workers from workplace safety and health hazards?
I don't know the law particularly well in that area. I'd be surprised if it did not have the authority to some extent.
Well, you see, in your opinion about home offices, this is what you said. In fact, didn't you say, argue against OSHA having jurisdiction over home offices? You said it is a basic principle of OSHA law that employers must bear the cost of eliminating unsafe work conditions. You said that in the Wall Street Journal. So you were willing to say it there. I'm asking you, why did you know it then? You don't know it now.
I was talking about what are called engineering controls when employers change the equipment employees are using, or that sort of change. And I did not have in mind personal protective equipment.
Mesh gloves, poultry, the kinds of things which are the most notorious, health and safety. You don't know whether the authority is there, but you do understand that with regards to more technical questions on ventilation or whatever, what was the other, what were you mentioning? Engineering?
Right. Engineering controls, changing the equipment, the machines.
So they do in engineering controls, but not with regards to the other. My time is up.
I think your answer was you didn't know the answer.
That's
which
correct.
is a reasonable answer, and I think very appropriate for this hearing, and I regret that that will be held against you. In fact, so far, from the evidence presented from the other side of the aisle, it appears that your basic detriments that might stand in the way of your being appointed to this position are, one, that you felt that there were problems with an OSHA regulation which the Congress felt was so bad it rejected it in a bipartisan vote in both houses. That seems to be the number one reason why you're being opposed on this, for this nomination. Secondly, that you're a lawyer and you represented clients. Well, my goodness, what a surprise. You're a lawyer and you represented clients.
I had mouths to feed, Senator.
In fact, I was very surprised to hear the senator from North Carolina, who is an outstanding lawyer, make the representation that because you were a lawyer and represented clients, you couldn't change sides as a lawyer and represent the other clients. When I was in law school, that was something we were expected to be able to do. Maybe the laws, maybe the treatment of the bars changed. Maybe you can only represent one side these days. My expectation is that you'd be a heck of an attorney for whoever side you decide to join. That's the third reason. The first was that you couldn't answer a question. And the fourth reason appears to be that you, I'm not sure there is a fourth reason. So let's return to the cause célèbre, ergonomics, and this issue of whether junk science applied to ergonomics the representation was that this was applied to something other than ergonomics. Wasn't junk science applied in the OSHA issues, in the 3 OSHA cases, to those questions involving ergonomics?
That's correct. The test that's popularly known as the junk science test.
Right, but I mean, it hasn't been limited to non-ergonomic, I think it was represented that it came out of a case that was decided on some other issue than ergonomics, which is reasonable. But it has been applied by courts in the ergonomics area. Is that not correct?
That's correct.
There was also, as I understood it, a concern that, and I guess it came from Senator Reid, that you didn't think there was a regulatory response to many of these issues. Was that a correct representation of your view? I mean, essentially he said, you don't believe in regulations, was what he was saying. Do you believe the Department of Labor has a legitimate regulatory role?
I believe it has an extraordinarily important regulatory role, and there isn't an OSHA rule on the books that I have opposed or that I have an objection to.
And you haven't opposed any of the rules, of which there are 140, according to, I think it was a senator from Wyoming noted, there are 140 different rules. Is that all? Laws. I knew there must be more rules than that. That's a ridiculously small number for a federal agency. But any of the laws, 140 laws. You haven't opposed those, and I presume there's a lot of rule-making authority under those laws.
That's correct.
And so, rather than being someone who opposes regulatory activity, you actually have been quite supportive of the initiatives.
I think the government has a very important role to play in ensuring worker well-being, including their safety and health.
And there was the further representation that you weren't going to be good at this job because you were going to be the government for the lawyer for the government. Sorry, the lawyer for the government. Is the solicitor the lawyer for the government?
That's correct.
Isn't a solicitor always the lawyer for the government?
That's correct.
So I think that representation has a few holes in the bucket, doesn't it? I mean, it's a little hard to carry that water. You know, I think your answers have been exceptional. They've been forthright. And so far, I have not heard any representations which in any way would undermine the views expressed by some very substantive people who were quoted by the senator from Alabama, one of whom happens to be in the room today, Mr. Coleman, that you would do a heck of a job in this position. And I'm looking forward to working with you, and I just can't see how your nomination could be opposed on the basis of the representations made here today. Thank you.
Thank you. I would look forward to working with you and all the members of this committee if I'm confirmed.
Senator Wellstone.
Thank you, Mr. Scalia. I appreciate your patience for a long hearing. To just build on what Senator Gregg said, I don't really think it's a question of whether or not you can switch sides, and it's certainly not a question of whether you're an able lawyer. I think, and it's the basis of my saying that I cannot support you, I think it's more a question of whether or not there's anything in your, in your background, your professional work history that suggests that you would be on the side of workers, that you would have the sensitivity and the compassion. I gave the example of poultry worker Mr. Frazier, and then we ran out of time. And what I'm having trouble, the reason I raise that question is I'm trying to look at your view of the world, and then I'm trying to look at Mr. Frazier's world, worker's world, and I'm trying to see how someone like a Mr. Frazier poultry worker gets the protection, gets the relief. I have here, this is just a summary of a lot of the cases that you've litigated and articles that you've written. It goes on for any number of pages, and I see not just opposition. I say to some of my colleagues, not just to the regulation, to the OSHA standard. I see opposition to guidelines. I see opposition to general duty enforcement, and I just don't see anything in your past, your work as a lawyer and what you've written that provides much help for Mr. Frazier. That's really what I think this hearing is about, which leads me to a question. We know of your, and you've said, look, I was a lawyer and this is what I was doing. We know of your opposition to repetitive stress injury rules. Have you ever filed comments supporting a worker protection regulation?
Yes, I have, and I provided congressional testimony also on the record-keeping rule, which I believe in the comments I filed, but also in the testimony I gave, I said it was a very important rule. I said it was good that OSHA was doing it so that employers could know where the injuries are occurring, so employees could, and so OSHA could.
This was, now could you go over that for me again, the specific reference of the comments that you're talking about? This was in which testimony or what case?
It was on the record-keeping rule, which OSHA finalized. But I'll concede, Senator, when you're representing the regulated community, it's relatively unusual to file comments asking for regulation. But that was one that, in a personal capacity, also I supported.
And I will concede that when you're representing such a community, it's rare, and I note not your tone of sarcasm, which I appreciate, but more the twinkle in your eye as you say that to me. But I think, again, that's part of the question of looking at the record and trying to figure out whether or not, given all the positions you've taken in your very career, how that squares with what I think is the mission of the Solicitor of Labor. Now, if I have a little bit more time, you talked about this article that you wrote for the Harvard Journal of Law and Public Policy, and you said this was an article where you expressed your respect, or you wrote about your respect for unions. I think that was your reference. Am I correct?
Yes.
Now, my understanding that this is also an article where you argue for exempting unions from programmed OSHA inspections and from Fair Labor Standard overtime requirements. If that's the case, and I want to ask you if that's the case, then the effect of the recommendation would be to disadvantage union members, causing them to bargain for matters for which all other workers would have. I mean, is that correct? Did you also in that article argue for exempting unions from programmed OSHA inspections and from FLSA overtime requirements?
This was, as you say, it was a law review article. It was written to suggest issues for discussion and consideration. And the general point that I was making was that unions do a very good job in many instances of helping their members, in a sense of regulating the workplace. And that's why we have the National Labor Relations Act and protect the right to unionize. And I said that consideration should be given in some circumstances to letting unions negotiate and perhaps alter the degree of their federal coverage if they thought it was in their own interest.
So you were arguing, you weren't arguing that unions should be, that you wanted to exempt unions from the OSHA inspections or from FSLA overtime requirements. You were saying that if unions themselves sought such an exemption, is that correct?
I think on the inspections, what I did was analogized to an inspection program during the Clinton administration, which had said if you have a safety program that includes employees, there wouldn't be inspection. And I said, well, what if you have a union that's effective in that area? I think on that point, I may not have said it was a matter of union negotiation. But on the overtime, I believe what I suggested was it would be a matter of union negotiation. I intended that article, as I say, and as is sort of clear from many passages in it, in a spirit of bipartisanship and to start discussion, but I did not. It was a little bit of a think piece, and I did not, intend it to be, a manifesto, but rather as the start of a discussion.
Well, I'm not going to try and, I'm out of time, and I'm not trying to score debate points with you. You are, I think everybody knows, very able. But I just want to point out that I think, I could be wrong, and I'm going to have to go back and look at every word, that you were talking about as something where you paid your respect for unions, and what have you now put in front of me here? I'll just look at this later. And my understanding, though, is, and from what I read, is that you then go on and you argue for exempting unions from OSHA and from FSLA, and it doesn't seem like, I haven't heard unions really calling for that or asking for that, and unless I read this the wrong way, it hardly seems like a piece that where you're really showing, I mean, it seems to go in the opposite direction of respect for unions. And the reason I mention this is it's in the context of all of the, again, as I look at all the writings and I look at all of the cases, I just cannot see. My question is not whether you can shift sides. My question is whether or not you can be an attorney, a solicitor for workers in this country. That's my question.
Paul, did you finish?
I'm out of time.
Yeah. Thank you, Mr. Chairman. And Mr. Chairman, could I ask unanimous consent that a letter from some previous solicitors of labor in a number of administrations be made a part of the record? Because thank you. It does make a point on the urgency of getting somebody in this position. It also makes a point of the important litigation decisions, the important enforcement initiatives, and the employment law violations that could go unaddressed with this position being unfilled. And asking, of course, for a review, and I appreciate having this review. I had my staff do some checking, and I have outstanding staff, but they may have missed something, but I couldn't find where we had anything except pro forma sorts of hearings on Solicitor Generals before, so I wasn't able to find what kinds of questions were asked of a Solicitor General before. I suspect if a full hearing were held that perhaps our side would have asked a question about how many employers the Solicitor General represented if he were from the other side. I suspect that perhaps we might have even asked the question about what kind of businesses they had run. I'm not sure that that's really appropriate to the position that you're asking about, but I will mention something on record keeping, and that's that I really share your opinions on the record keeping. And I may be the only one in the Senate that has filled out the OSHA accident forms. I was an accountant, and that was one of the jobs that was given to me. And I've got to say that's the most worthless piece of crap I ever did. There isn't any value to filling out that form, so when I got here, I was really excited to find out what happened to it. Nothing happens to it. The biggest use for it, of course, is that use that in January that the employer has to post it on the board to show his employees what accidents happened. And if that can't be improved on, then OSHA needs to find another job. Just posting it doesn't do any good. Just posting it in January is probably the worst time to post it. Encouraging employers to not only keep track of what the accidents are, but to keep track of the near misses and let their employees know what could have happened and how to avoid it would be much more useful. So I appreciate your point on the record keeping. I also appreciate the point that when you represented a client, you were one-sided. It has always been although I'm not a lawyer, it has been my understanding that that's how the law is supposed to work. When you pick a client and you represent them, you're supposed to present their side. You're not supposed to make the case for the other side. So I can understand how some of these statements that you made while representing a client might be more one-sided than you might otherwise feel. To get to the questions, one of the reasons that ergonomics effort did not pass was because of the process that the OSHA department used. And I'd be interested in knowing if you have a say in how the process will work. And what I'm referring to specifically is that people were paid to testify. Then they were brought in to practice testifying. Then their testimony was rewritten by the department, who it was always my thought was supposed to be unbiased in the situation. And then, worst of all, they were paid to rip apart the testimony of the people who paid their own way to testify. Would that be a job of the Solicitor General to advise which instances things can be paid and what would be correct opportunities for payment?
Yes, that would be a function performed by the Solicitor's Office.
Another thing that bothered me, and evidently a lot of other senators and House members, is the comments, which were about 78 feet of them, so I can understand why you haven't read them yet, were reviewed in less than a month and then not reflected in the final document. In fact, the final document went the opposite way from the majority of the comments. And the reason I'm curious about this and interested in this is I think we could start a whole new trend in rules if we allow a department to put up what might be a milquetoast rule and get unanimous comment in favor of it, and then reflect a much tougher line when the final rule comes out. Is that something that would come under your jurisdiction?
That's correct. Compliance with the Administrative Procedure Act is important to rulemakings, and it's those kinds of issues that the Solicitor's Office would have its principal involvement, as I understand it.
Mm-hmm. Do you have any difficulties with these things that I've mentioned? Are they things that, well, I won't even ask the question because
well, I guess I shouldn't answer the question if you didn't ask it.
I'll go ahead and ask the question. You go ahead and answer.
Want legal advice on that?
There were difficulties in getting the task done in the time that was allotted for it during the last rulemaking. My impression was that OSHA and the Solicitor's Office worked exceptionally hard, but it was an awful lot of work to get done in the period that we were talking about.
Would you work to be sure that the testimony taken is unbiased from the department's standpoint?
I think it's the department's responsibility to enable a spectrum of views to be expressed and to establish procedures that allow that in an unbiased manner. And I think it's the department's responsibility to review those comments and the testimony in an unbiased fashion.
Just very quickly and without an answer, but I'll submit this in writing to get an answer. And what your position would be on making a rule tougher after the hearing was held, and whether you as solicitor would have the right to have them do another hearing after that time. I'll submit that in writing. Thank you.
Thank you.
Thank you, Mr. Chairman. You know, regulations are a part of life. I think our big concern is that if we have a regulation that imposes a cost but does not produce a benefit, then we ought to look at that with some concern. I have filed a number of cases on behalf of workers against entities in the last 10 or 12 years. And in private practice, I remember two on overtime, one against a business and one against a union. The union didn't properly compute the overtime, and the employee came to me, and we won both those suits. But so I think what you're saying, Mr. Scalia, is that you believe in the law, you believe in the rule of law, and if the overtime is necessary or the safety rule is clear, you will seek in every way possible to enforce that rule or law or court case. Is that correct?
Absolutely.
Whether you agree with it or not?
Whether I agree with it or not, that's right.
And you've been asked, well, you have a circumscribed view of your role, but as I understood your question, let me ask you if this is true. You are simply responding what your legal responsibilities are, what your position calls for you to do, which isn't to provide policy advice on every matter that comes before the Department of Labor. Is that correct?
That's correct, Senator. At times, other issues may get raised peripherally with the solicitor. The solicitor doesn't have an obligation to sit mute in every meeting. But I think it's very important for a lawyer to be reliable for legal advice. And if a lawyer takes on other things, the lawyer becomes less reliable as a lawyer.
If the secretary asks you some matter unrelated to your duties, I assume you would give it your best answer, but in your best answer to the questions you had here, you were referring to what your legal responsibilities are as the solicitor in the Department of Labor, which is a circumscribed role in many ways, is it not?
That's correct.
Officially. On the sexual harassment questions you were asked and on the article you'd written, is that the same article, and Senator Reid asked you about it, that Justice Ruth Bader Ginsburg, who most would say clearly the most ardent defender of women's rights on the Supreme Court, is that the article she wrote you about in which she said, your article is written with refreshing clarity and style. It is informative, thought-provoking, altogether a treat to read?
That's the same article, Senator.
I don't think she would have written that if she thought you were off the world somewhere in your views on that. And I want to say about Senator Enzi, he has worked so hard to improve OSHA. And the goal that Senator Enzi has worked on, and I support, is to make OSHA a vehicle for a clearly improved and more safe workplace without having it be a coming along after a problem occurs and with a gotcha mentality, to try to make it a positive force. That's not your role, that's our role to deal with that, and we work together on it, and he has worked dedicatedly to make sure that we have an OSHA that's out inspecting before accident occurs, encouraging, helping, advising businesses how to have a safer workplace and reduce injuries. And I think he has made some points about the OSHA bureaucracy and the procedures that are valid. Just because they're known as OSHA does not mean they can't be an arrogant, bureaucratic, non-responsive agency. And sometimes it deserves criticism. This Congress voted overwhelmingly, or with a significant bipartisan majority, to reject their OSHA regulations and to send them back for further review by the Secretary of Labor, which is happening today. But I just want to say that OSHA has played an important role. I believe we need to look at it today to see how we can make it more effective in preventing injury and reduce its bureaucratic mentality. You don't have to comment on that. If you desire to do so.
I understand that OSHA is important to all the members of this committee, and I would look forward to working with them on it if I'm confirmed.
And I hope that you would take to heart and in your role as you're able to make sure that if we have information that both sides get heard, and that you'll encourage people to do that. I'm extraordinarily impressed with your testimony. I think you've handled yourself just wonderfully today. You have been professional and thoughtful and responsive and humble and brilliant. So I congratulate you, and I know you'll do a great job as solicitor.
Thank you.
Very much. I think the way we'll proceed now, Senator Wellstone has a brief question or two, and I'll make a very brief final comment.
I'll be very brief because I know we all have to go to caucus luncheons. Just following up on Senator Sessions, Mr. Scalia, in case you haven't noticed, this is a very diverse committee.
I've noticed.
And I want to respond to the comments of my colleague, Senator Enzi.
Senator Wellstone, I want you to know that the only lawsuit I've had against a union was a winning lawsuit from its own employee for overtime, failure to pay overtime.
Well, that makes Senator Sessions. I wouldn't doubt.
Speechless, I can tell.
No, that never happens.
He's just used all his time.
I'm so impressed with what Senator Sessions told me, I can't think now. I wanted to point out that, just for the record, unless I'm wrong, I had asked you whether you had filed comments supporting a worker protection regulation, and in the House subcommittee testimony, you had talked about, had given OSHA credit for the efforts to codify the record-keeping requirements. But I also want to point out that you had recommended changes that would change the definition and criteria for recording work-related injuries and illnesses, and if implemented, would reduce the number of injuries and illnesses now being recorded. Now, I want to point out that I don't actually see that as being testimony that supports worker protection regulation. I would disagree with Senator Enzi. I wouldn't consider this to be, quote, this record keeping to be, quote, whatever he said. But I think that when you have less reportings, I mean, part of what you're doing is you are taking away an important foundation of worker protection. That's how we know what's happening in the workplace. So maybe I'm wrong, but in that same testimony that you cited, am I not correct that this was what you had said?
On that point, you're right, Senator, and if I gave the impression that I supported the rule in full, I appreciate your clarifying it.
Okay, I thank you. And with that clarification, let me just thank you for being here today. I appreciate it.
Thank you very much.
Thank you. I didn't get into your views about also discouraging even voluntary regulations by businesses in terms of ergonomics. I don't know whether you want to make a brief comment on that. You know, where you co-authored the article, well, you included in the UPS brief, you call the state, UPS believes that issuing prescriptive RSI, repetitive syndrome, guidelines would be as ill-advised as establishing a standard, perhaps more so. And then later in the year, you wrote the same vigilance is needed, God, to industry occasions of immediate concerns, the potential disastrous ergonomic standard being set by the American National Standards Institute. As long as it asserts that repetitive work motions cause injury, it threatens to enhance greatly OSHA's litigating position. So it's not only opposition, any standard, even where industries were trying to develop that. I don't know if want to make a comment on that.
I did encourage employers to look closely at ergonomics and to address employee complaints and to adopt ergonomic measures. The standard setting by these associations concerned employers because sometimes after the standards are set, OSHA uses them in prosecutions, and so some companies, and one of my clients was included, didn't support those voluntary standards for that reason.
Well, thank you very much. Just in a brief comment at the end, As has been mentioned during the committee, the Solicitor of Labor is no ordinary responsibility, no ordinary appointment. The Solicitor of Labor is the workers' lawyer, and he is their representative. And he is responsible for protecting the basic interests of literally millions of working men and women in every community and every workplace in the United States. So this position requires a person who will have the confidence of America's workers and their rights. And their rights are being rigorously protected by the Department of Labor. I think appointing a solicitor does not believe in the dangers of ergonomics, because it's like appointing a high official in the Environmental Protection Agency and doesn't believe in the existence of pollution, or a high-level official in civil rights who doesn't believe in discrimination. We need a solicitor whose background and experience reflects a commitment to the fundamental rights and protections of workers across America. I respect your ability, Mr. Scalia, but I continue to have the gravest reservations about your nomination for this very important position. Committee stands in recess.
Yeah, in a lot of ways, I think personally,